Hello, good evening, everybody, and thank you so much for having me here today. First of all, I would like to thank you all for joining this session. And going further, I would like to introduce myself. I'm Jagriti, and I'm an internationally trained lawyer and a solicitor, and pursuing my barrister with LSO, and I'm working with one of the law firm in Burnaby, BC. Today we're going to discuss law of remedies, and I am aware today's section or today's session may bring up lot many questions from you guys, and I want you guys to know that I will try to answer as many as in today's time. And going further, I always advise because I already had two successful teaching sessions of law of properties with 98% result ratio. And I always advise them to print a syllabus for them because for me, syllabus is a Bible. So if you want to pass this subject, it's very important that you understand what is your syllabus and how it is connected to different topics and what are the relevance of these topics. So it is really, really important for you guys to print that syllabus and have a very elaborated look that how many chapters do you have and what NCA wants you to understand and what is important to pass this subject. That is the most important thing. Sometimes you have utter knowledge and a big knowledge about everything, but again then it is difficult to pass exams because of the relevance and connection of these topics. So I hope by the end of this session we will walk here with more confidence and more understanding and knowledge of law of remedies and its application and execution under Canadian legal system. So I'll run you through the law of remedies now. Law of remedies mainly deal with the civil law in a common law jurisdiction. So it's very important for you guys to understand what is the purpose of this remedies and why we provide these remedies. What is the basic function of these remedies? So these remedies are also known as judicial legal remedies. Yeah, anybody is anyone asking any question? Hello? No? Okay, so we're going to continue now. So it's very important for you guys to understand what are the basic purpose, what are the types of remedies, and what are the basic limitation because very soon in a future, as in legal representatives, you guys will be recommending and advising your clients what are their remedies and what are the limitation on their remedies. So it's very important for you guys to have very concise and very concerned knowledge about these limitations and types of remedies. So those who already wrote torts and contracts can relate this subject very well because basically we always deal with remedies in torts and contracts, but those who doesn't have these subjects, they need to understand how it works, why, what are the purpose, what are the relevance. So we always need to understand first of all what is very, very important to pass this subject. So again, when I was preparing for this subject, I cleared my law of remedies in a first instance in January. And when I was preparing for this subject, I used to watch lot many YouTube videos on remedies, and I used to read a lot many articles because there is no tutor available for this subject, and it's really difficult being a beginner to connect this. And finally, what I understood is this subject is completely divided in two parts. And after writing this exam, I get to know it actually divided in two parts. NC gonna get you almost like on every part of it, but basically it's divided in four questions. Your examination paper will be divided in four different questions, and two will be almost contract remedies, and two gonna be torts remedies. So they're going to confuse you because it's very basically we are talking about same remedies, either it's going to be legal remedies or equitable remedies. Now you need to figure out if it is a breach of contract or if it is a tort. So very first thing you need to figure out from your examination question is where it falls, if it is a contract breach or it is a tort. So once you will figure out this thing, it will be more easier for you to consider which remedy apply here. So we are not going in very deep conversation today because this is an introductory class, and I want you guys to understand the basic ratio and connection and relevance. So again, whether you are joining this class or you are not joining this class, I'll advise you guys to just make a two different segments, one for a contract and one for a torts, which gonna help you to understood, to characterize, to bifurcate the subject. And as per your syllabus, NCA bifurcated this subject in 9 chapters. And if you thoroughly check your syllabus, you will figure out first half is legal remedies, which talk about damages and everything, and the second half is equitable remedies. So what are the difference and why the this is categorized in this subject, whole subject is categorized in two different remedies? Because somewhere you cannot you cannot provide the same comfort or same justice to the person with damages. So it's not easy to just comfort other person or a wrong to punish wrongdoer with a damages or something. So it's very important to have equitable remedies as well. So if you guys are having a contract with somebody and that person breaches the contract, definitely you don't want those damages, you want that contract to be completed. In those cases, court always try equitable remedies by performing specific performance. So now we're gonna discuss four topics in our today's class. Very first topic is what is the purpose of these remedies when we have civil law, when we have criminal law, why we need to concentrate and why we need to categorize everything in civil remedies. So I would like to ask you guys if anybody wanna take a stab here and try here why we need remedies. Why not the civil law when it is dealing in a civil law jurisdiction? When we already have civil law jurisdiction and we already have everything, then why we are talking about these remedies? So I would like to ask you guys if you guys want to take a stab here. Anybody? I know you guys are taking this class for the first time or maybe haven't even started your remedies subject, but let's just take a conversation, just a normal conversation. What you guys think? Why we need remedies?
I guess if you were wronged, you kind of want to be compensated for whatever that you've been
Yeah,
like,
right.
whatever that you lost, basically.
That's very much true. So we always see sometimes civil procedures are there, but they always go for remedies. Why? Because it comes with successful lawsuit only, but it saves a lot of time and it's easy to decide like this is a damage and this might be a remedy. So it's very easy for one person to decide like what's going to be the remedies. If you are a lawyer and you have a client which comes to you for a breach of contract, you will instinctively think like okay fine, it's a breach of contract, we will get a remedy. So this is how it works. It balances the interest very quickly. So it's very clear, if it is a breach of contract there is a remedy, if it is a tort breach there is a remedy. So it balances both interests very quickly. So it's easier for the judicial system also, like they don't need to go into common law authorities and figure out what's going to be the remedy now. So it's easy to balance interest very quickly. Then we always talk about morality. It keep our society civil, and it tells everybody they have a moral obligation, because if they do wrong, there is they have to pay remedies on it. So it might not take very long to understand that okay, don't break rules, don't break contract, don't do tort breaches. Those are very civil things. Like people always think okay fine, it might be fine, but no, if there is a remedy it will be a check and balance on them. If you will do this, you will be categorized as in a wrongdoer, and there will be a need of remedy, right? So this is very important thing. And last and a final thing is a justice. So we always tell our client, okay, fine, I can see there is a breach of contract or you want to file tort suit. But again, we always tell them court will attempt to provide basic remedy. There is no guarantee. Court will look into the whole matter, whole scenario, evidence, and then they're going to talk about, they're going to attempt to provide remedy, and they're going to attempt to provide justice. So this is how, why court gonna do that? Court always wanted to protect morality. Court always wanted to protect civility, so that everybody should follow rules, laws, regulations. And when we talk about remedies, it's always categorized in three ways, but in your syllabus, NCA provided in two different topics. So first is a legal, if you can see at the slide number 2, first is a legal remedy, and second is an equitable remedy, and then there is a declaratory remedies. But NCA wants you to focus on legal remedies and equitable remedies. And secondly, when we talk about legal remedies, it is again categorized in two parts. One is the damages and one is a monetary relief. Basically, both talk about same thing, but when we talking about damages, sometimes we talk about like equipments, maybe your car, maybe your furniture or anything. Like maybe court want you if you don't have a monetary value of the same, maybe court want to fulfill others damage, so they're gonna talk about your equipments or your things, right? So damages cover a little bit of that also, but monetary relief is completely talking about money. So you have to pay damages in currency. So this is a little and very slight difference in damages and monetary relief. During our exam, they very smartly portrayed this difference. I just remember the question. They portrayed the question where the wrongdoer wasn't well-to-do and doesn't having any money to pay damages. He was jobless and he wasn't having any property, but he was having a yard kind of thing. So finally, they wanted you to understand, if wrongdoer doesn't have anything, it doesn't mean he's not in, other person is not entitled for any remedy. Whatever you have, you can pay damages by that property, or whatever personal property or any kind of property you have. So that is very slight difference between damages and monetary relief. I already mentioned in my IREX very clearly. If you can figure out from your facts in hand during your exam, whatever facts NCA provided you, you can always mention in your answer as per the facts in hand. Maybe person doesn't have a monetary value to fulfill the damage of the other person, but that person has a personal property or any kind of real property, and he is, other person is entitled for his damages. Are you guys getting it? Or you guys want me to go a little slow or fast?
Everything's good for me from my side.
Perfect. Thank you. And second kind of remedy is a equitable remedy. You're going to definitely get two questions out of equitable remedies. The equitable remedies are again categorized in three parts. One is a specific remedies, one is an injunction and restitution. So equitable remedies mainly deal with contract breaches, because if there is a contract breach, they always ask, court always orders specific remedies. They want one party specifically to perform whatever the contract was there. They want one party to fulfill the contract to avoid damages of other party. So wherever you see contract question on a contract breach, quickly practice your mind to think about whether it fall under specific remedies or injunction or restitution. For that, you guys really need to understand what is specific remedies and why it should be applied, why it should not be applied. So very important for you guys to understand this term. Injunction is equitably important because sometimes injunctions are granted and sometimes not, but you need to understand where you can demand for the injunction and where you cannot demand for the injunction. So you need to understand before you apply these remedies. It's very important you should understand the relevance, the connection of the facts with these things. And in contract breach questions, they always talk about, like in our exams they said there is a person, there was a lady. I'll just quote an example for you so that that will interest you guys to understand what kind of questions NCA put it there. So in our exam they just mentioned there was a house, and constructor contracted that he will build a aquarium of the wall size, and the party left the country after signing the contract, and after few months contractor realized it wasn't possible for him to build a aquarium of wall size. uh, what he did not try to reach out to the party, and he himself decided to minimize the size of the aquarium. Now, by minimizing the size of the aquarium, there was special species of the fishes which doesn't fit in that aquarium. And those fishes are very, very important for the client. Now, a contractor breached this contract without the permission or without taking any consideration from the client. Now, what you guys think? What kind of remedy a client is entitled for? There is a breach of contract, we figured out. But what you guys think? What kind of remedies this client is entitled for? Anybody? Just give an answer. Don't, I know you guys are not prepared for this subject right now. It's just a general discussion. So you guys can just take a stab here.
Maybe specific remedy,
Yeah,
specific
yeah,
performance.
that's right. Specific remedies. Why? Why you think? Why not restitution and why not injunction? Okay, I'll explain it for you guys. Because
Okay.
injunction doesn't make any difference here, and restitution is not important here. That client wants aquarium of wall size, so it does not matter what is monetary value of that damage, and it does not matter what gonna be the injunction, what kind of injunction. Injunctions are always of two kinds, so it doesn't fit there, but he want that aquarium. So he always he apply for the remedy that contractor should complete the aquarium as per the contract. So now a court gonna say, okay, there is a specific, there need to be a specific performance as per the contract. So that contractor has to bear the extra cost, whatever will be there, to complete the contract. So this is how you guys need to figure out. I know it was a very random guess, because when you're gonna study further chapter by chapter, it will confuse you. Why not injunction? Why not the damages? Contractor can pay damages of his fishes, and go on. But it's not always how. There is a there is an ingredient of mental this thing, like if your work doesn't give any kind of relief to your client, and any kind of disturbance to your client, you cannot go further with that. So there are different ingredients which you need to put it there, which you need to tell your examiner, this is something I'm relying on. Maybe because client, for a client, his fishes collection is very important. He collected those fishes since many years. So that doesn't make monetary relief, doesn't make any doesn't make any difference for him. It doesn't help. He want his fishes to be in his house. He spent all his money and all his saving to build this house, and if he can't live with his favorite thing, that is not a remedy for him. So you, there is many things to consider while drafting your answer. But you can once you will start study remedies, you will get to know what is important and what is not important while drafting these remedies. So I think everything is clear so far. Can we move on to next slide, or you want me to repeat anything here?
No, everything is clear.
Perfect. So it is clear that there are two types of basic remedies, legal and equitable. Legal remedies are again divided and categorized in two parts, and equitable remedies are categorized in three parts. So this is very basic thing which is clear, right?
Yes.
Perfect. So moving forward, we always say, okay, why? What is this basic purpose of the remedy? So if you go to slide number 5, I mentioned the fundamental purpose of remedies is non-criminal cases is not to punish the breaching party, but if possible, to put the non-breaching party in the position he or she would have been in had there been no breach, or as is said the purpose is to make the non-breaching party whole. So just to cover the loss of the non-breaching party. And if you guys studied the contract, or if you guys have a contract in your challenging exams, you will always see whenever there is a breach of contract, court always try to put the party in a same position where it was, right? Or if it is not possible, it's always like monetary damages or something. So if it is something which you have done wrong and you breach the contract, then court always see if it is a legal contract and a valid contract, court always wants you to put in the same position where you work. So what is the basic purpose? Purpose is same, to cover the loss, to cover the damage of the aggrieved party. So they always want party to be in the same position. So that is the basic purpose. To and you need to tell this in your answer. You have to start your answer with this. It's just not for your knowledge sake. When you start drafting your answer, you need to tell your examiner what is the purpose of this remedy, why you are applying this remedy, because there is a damage of this person, there was a legal contract. You need to tell, even in your contract breach answer, you need to tell your examiner there was a legal contract between two parties and this party is entitled for damages now. And it is the basic purpose of applying this remedy here is to make this party in the same situation where it was before the breach of the contract or before the creating of the contract. So you need to start your answer with this language. You need to, first of all, you need to tell your examiner the basic purpose of the remedies. Remedies exam is not that easy exam, because I know somebody who appeared with me was trying for the second time. So what I'm telling you this, guys, so that whenever you will draft or challenge this exam, you should take concentration and you should pay attention to this thing, how to draft your answer. Sometimes you are very knowledgeable regarding this subject, but drafting an answer is an art in NCA in all subjects, not even in remedies. So very importantly, just make a chart for yourself. What you're gonna do, what you're gonna apply now, why you gonna tell this, what happened, and what are the relevance of this. So with your case laws, tell your examiner this also. Purpose. Moving forward, when we already told our hello, hello.
Yes, we can still hear you.
Yeah. So moving forward, once you told your examiner why you are putting this remedy here, what is the purpose of putting this remedy here? The second very important thing you need to tell your remedy, what is the category of the remedies you are going to apply now? Whether it is a equitable or whether it is a legal. Why you need to tell this examiner? Anybody want to take stab here? Why you think you need to tell your examiner whether it is a equitable or whether it is a damages? So in a
Sorry, can you repeat the
yeah,
question?
yeah, why you need to tell your examiner under what category this remedy fall, whether it is a legal remedy or equitable remedy, what you think? Why you need to tell this to your examiner?
So that they can judge our answer accordingly right away. I mean,
Yeah,
uh,
there are many things. Why? Because one, if it is a damages in a monetary relief, they may ask you calculations. Okay. So they may ask you because in a further chapters you will read that they may ask you calculation. This is why you need to tell it is a legal remedy and there is a monetary relief remedy. There are damages, and It is very important to tell so that they understand that you know two types of remedies, you know what to apply here. So this is important to tell your examiner at a first instance after telling the purpose. Okay, as per the facts in hand, I think this person is entitled for a legal remedy, or as per the facts in hand, this person is entitled for the equitable remedy. So you need to tell this to your examiner and then start the next step so that he knows about it. You need to tell him like whether it's falling under the contract breach, whether it is falling under the tort suit, and why this person is entitled. But before that, tell your examiner this person is entitled for the legal remedies or equitable remedies. So put the step two to tell your examiner under what remedy this person is entitled for. Okay, so I already mentioned when it is a specific and when it is injunction restitution. I prepared this slide specifically for you guys so that you can have a little introduction, because I know it takes time to understand everything. It takes a lot of calculation. Why specific? Why injunction? Why restitution? Why legal? Why equitable? But basically, basic structure is divided into legal and equitable. And when we are talking about equitable, again in three categories. And when we are talking about legal, again in two categories. So far you need to tell this thing, right? Why are you thinking why equitable and why legal? Then you need to you need not to tell this to examiner what are the difference between two, but you need to understand what are the difference between equitable remedies and legal remedies. Why? So that you can when I joined NCA and when I started NCA, they used to tell this is very practical based exams. This is not theory based exams. So you need to identify the keys in exam. So what are the basic keys? If you figure out the keys in exams, then it will be better for you to draft your answer in a specific manner. So this just to figure out the keys and just to figure out what is important and for a right answer, you need to understand what is the difference between equitable and legal remedies. So we'll start with the legal remedies. So legal remedies allow the non-breaching party to recover monetary damages, right? So it's fine if let's quote an example. Let's see who is here. So Daniel. So let's see if me and Daniel have a contract that okay, I'll deliver this thing to your place by Saturday, and it gonna and the monetary value of the same thing, um, of the such event or delivering the thing is $50. Now, what Daniel did, depending on my promise or depending on my contract, she further contracted to someone that she gonna deliver this thing to maybe Ismeet, right? Ismeet, and she invested $50 more for delivering the thing to Ismail. So I missed to deliver right at the time, I'm like on Saturday, right at the time to Daniel. Now what happened? There is a loss of $50, but there is not only the loss of $50. Daniel invested by relying on my promise $50 more. So Daniel has a loss of $100 now. So is Daniel entitled for the remedy of $50 or $100?
I would say 100.
Yeah, she's entitled for the remedy of the $100. So if somebody, by relying on your contract or your promise, invest further, then you are entitled for not performing that thing. Now, what court gonna do? There are two things. Because in any case, even if court say, okay, fine, I'll go for equitable remedies and I'll ask Jagriti for a specific performance, she has to deliver this thing to Daniel now. Will it cover Daniel's loss, the further loss of $50, which she promised to Smith? No, because she promised to Smith to deliver it by Sunday, and Sunday is over now in court proceedings. So it doesn't cover Daniel's loss of $50 of investment. Even if I'll do specific performance and I deliver my parcel to Daniel, it will not cover Daniel's other $50 loss. So specific performance is not the right remedy here. So what is the right remedy here? Monetary relief. I have to pay Daniel $100, $50 loss for whatever not delivering myself, and $50 which Daniel invested with Smith by relying on my contract and promise. So you guys understood that? How specific performance wasn't the right remedy here, and equity monetary relief is the right remedy here. Hello? Or you guys want me to quote in another example?
No, I think
So
well, I'm
you're
good.
s-
Go on, please.
so I did not understand the part where you said that it's
So
like
I'll
Sunday
quote
has gone
another.
and time has gone. Okay,
Okay, I'll quote another
thank you.
example, right? So Daniel is a constructor, and no, I'm a constructor, and I'm building Daniel's house. And I told Daniel, okay, I will complete construction by the month of February. You understood this much?
Yes,
Okay, now what Daniel did by relying on my contract and my promise, Daniel promised Smith that she'll buy this house she'll sell this house to Smith in the month of March. You understood this month? So,
yes, yes.
okay, perfect. Now, due to some reason, I did a contract breach and I did not completed Daniel's house by March. So that means there is a contract breach, right? I did not completed Daniel's construction house's construction by March, and Daniel is not in a position to sell this house to Smith now by March, right? You got it this month so far.
Yes.
So now, if court says, now we have basically two kind of remedies. One is a monetary relief, and one is a specific performance. So, do you think if courts say, okay, Jagriti, Daniel is entitled for the remedy, and please complete her house by May month, is that appropriate remedy? Will it cover Daniel's loss, which which she had by not selling house to Smith?
No,
No. So what gonna cover Daniel's loss? The contract
monetary.
breach which I did to Daniel, and whatever loss Daniel had, which she's not in a position to sell this house to Smith now, right? So she might have $50,000 loss now. So I have to cover now. The better and the best relief is a monetary relief to cover Daniel's all losses, whatever investment she had, or whatever loss of investment she has, whatever loss of investment plus whatever time we're gonna go further now. So we need to cover monetary relief here. Specific performance will not work here. So we need to we are not here to see just Daniel's loss by having contract breach between us. We need to see if Daniel invested further by relying on my promise. You got it?
Yes,
Perfect.
yes, I understand now. Thank you.
Yeah. So it's important to see many factors rather than seeing one factor. But of course, this is not expected now, because once you're gonna study further chapters, you will understand this how it works. So this is the basic difference why monetary and why equitable remedies. And when we talk about equitable remedies, let's see. Me and you have a contract. Your name is, okay. Let me figure.
Marjan.
Okay,
My name
Marjan.
is Marjan.
Okay, Marjan. So let's take it this way. You and me have a contract, right? I'm a constructor, and you told me, okay, Jagriti, I earned whole my life, and this is my saving, and this is my dream house, and I want it this way. I want you to make a artificial lake around my house. Why? Because you have lot many water bodies, and you want them, right? So let's see, you and me had a contract. Now, I told you, okay, fine, I'm okay with it. We're gonna make an artificial lake around the house. But after some time, I realized that I promised, but it's not possible. It's not
Mm-hmm.
possible in the cost which I provided you. It might take 10 to 12,000 more. So after sometimes I realized it might not be possible in $20,000, which I contracted with you. It will take $35,000, right? So now I told you, like in the middle of the contract, like after 4 5 months, like it's not possible, and we need to increase the cost. Is I'm entitled to increase the cost now after a contract?
No, I don't think so.
Yeah,
Once a
no,
contract, it's
because
binding.
one, yeah, you gave me quotation. I gave you quotations, and I gave you quotation myself. And now after 3 months or 4 months, I cannot say, okay, there is a $15 cost extra, $15,000 cost extra. I cannot say that. So I told, okay, fine. In $20,000, I cannot complete this artificial lake. I cannot do it. Now you went to court. Do you think whatever $20,000 I invested, that if court will say, okay, fine, Jagriti, you have a damages of $20,000, it's fine. Um, Sorry, if court will say, okay, Marjan, you have a
Mhm.
damage of $20,000 and Jagriti will pay $20,000, does it solve your purpose now?
No, I still won't get the
What do you think?
approval.
What kind of remedy will suit here?
Specific performance, get
Yes.
the contractor to
Then you
build.
will, yeah, then you will file an application in court that I don't want damages, I want a specific performance of this contract. So you will
Mm.
file an application for the specific uh, performance, not for the damages. There is no application for damages should be filed for this kind of losses. So, but there is again number of factors. There is a case in your remedies regarding the same type of cases where person, promised the specific kind of carpets, and then he realized there is a strike in Arabian countries and he cannot import those carpets to US, and he cannot complete that construction on time. So there is then you need to see time, then you need to see the assessment, different kind of assessments. This is very straightforward, but when you are drafting your answer, it will not be that straightforward. You need to see lot many assessments and calculations, but in our uh, next classes we can talk about it. So this is how you're going to categorize what kind of remedies suits here. And when we talk about contract cases, we always say, okay, fine, if you see these companies, corporates, they always ask their employers to sign some documents before they hire them. Even if they buy some property, they always do a lot of paperwork. What do you think that what that kind of paperwork is? There are many, many clauses involved in those hirings and purchases. And one of such clause is a limitation clause. So in future, if you are trying to claim something, you need to check these insurance policies. They always put, whenever you buy insurance policies, have you ever noticed there are very, very in a very minimum or minor languages and very small fonts, they mention lot many things. We don't even care to read those things. But what are those? Those are clauses which they put there specifically, and you sign it, and you don't mind signing it. Later on, when you realize, oh, okay, fine, this is not something I wanted, but you can't do anything at that time once you sign it. So those are like limitation clauses. So the
Like
only limitation,
loopholes,
sorry.
like
Yeah.
loopholes in a contract.
The limitations on a remedy, the basic limitation on a remedy is a limitation clause, and NCA knows it very well how to check that. And lot many people miss that thing in a facts. And NCA always want you to know, because if you guys, one of you guys want to become a corporate lawyer or a business lawyer, you need to know how to read those clauses. You need to figure out those. So they very specifically mentioned that thing in a one fact pattern and they want to check because I have seen many times and see I'm like I might not say that, but in some reports or somewhere I have seen that people miss limitation clause because when we do a study we always see okay fine there is a limitation clause, but how to figure out that limitation clause language in your fact pattern, put concentration on that. That's very important for you to understand because your answer will not complete, specifically in contract breaches, because whatever contracts you have there is always a clauses in contract. There's always a limitation clause in a contract. I can understand when you have a taught question you can keep your mind at ease, okay fine there will be no limitation clause, but when you are trying to attempt contract clause, check contract question, check for the clauses, limitation clause, it's important. And in a contract breaches, those are the survivals, right? So, as I promised, we're going to discuss four topics now: purpose, difference, categories, and limitation. I think I just summarized all four steps for you guys, but remedies are much more than this. You will not understand in a 1 hour's class or 1 hour's introductory class. It takes time to understand the whole thing. So I do have notes and I do have IREX and PPTs for you guys to go through. Most of the time, what I realized when I joined NCA, people used to talk about IREX more, like if you have an IREX you can pass these subjects and these NCA is more easier with the IREX. But what I realized in my last two property law classes, if you guys are not aware, my classes are available on YouTube as in Jagriti Jaswal property law classes. You can always go and have a reference there. So most of the student, I have 25 students in a one batch and 18 in other, they were more happy with the PPT slides. They took those PPT slides to exam rooms, and they said they always quoted that they answered their question with their questions with those PPT slides. But though I prepare or always prepare IREX for them because those are like summarization of your subject and steps to follow while drafting your answer. So if you join these classes, it's like I have notes, PPTs, and IREX for you guys, and I have few questions to practice with you guys. Definitely, we're gonna practice NCA sample questions, but other than that, I have few questions to practice. So this is all for today. I can say about remedies. Now we're gonna go for the question sessions. If you have any questions, we're gonna discuss now. So go on if you have any questions today.
So I'm still not able to download the PowerPoint
PP.
presentation. Is there any way you can share it on
Yes. We're gonna
Facebook Messenger?
yeah, sure. But
Mhm.
Facebook Messenger, I'm not sure if I can share it there or not. But if you want, I can email it.
Yes, please email it to me.
Sure. Anybody else have any questions regarding remedy classes?
So yeah, I just want to ask, are your notes gonna have like details about the cases, or are we gonna have to do any additional studying or reading from the textbooks?
I always recommend textbook even to my property law students. Why? Because I always like to study in a elaborated manner. So notes are enough, but again, because NCA changed syllabus a lot, so I'll be preparing for the new case laws in our next classes because I won't. I'm sure if they change the syllabus and they just added six new case laws, they will definitely gonna ask question on assessment of time this time because last time when we were writing this exam, there wasn't assessment of time was not that prominent. It was there in a book, it was there in a chapter, but not that prominent. As there were no case law regarding assessment of time of damages, right? So this time they added few case laws on that. So I'm sure they're gonna test you guys on assessment of time also. So I'll be preparing those also. Any
I
other?
I had a question. How long are your lessons going to be? Like how many? And also, how long do you like recommend that a student studies for to pass the exam?
Yeah, so I think you guys have 9 to 10 chapters as per the new syllabus. I just had it, I download new and printed new syllabus for you guys. So there are 9 to 10 chapters, and I'll definitely recommend 7 to 8 classes and one examination workshop because you guys having exam in a January. So what I'm gonna try to do is I just want you to give you guys a week before a exam because I don't want to take any classes before a week. I wanted to finish before that so that last week you guys should concentrate on your own study and keep your mind at ease. So I think we will be in a position to conduct seven to eight classes. Yeah, and if we talk about study, there are two things. The one who already wrote contract and torts, they're gonna get this subject little easy. Why? Because they know how tort thing works and how contract breaches work. They have knowledge about those. So they just need to work on and a focus on a remedy part. But those who doesn't have those two exams in their assessments, they need to put little more time. They need to focus how these contract breaches works and how what are this tort and what are negligence and what are invasion of privacy. All this they need to understand a bit so that they can apply remedy in a better way, because if you don't know where you applying remedy, it's a trouble. So it's better to understand what tort is and what contract is. You need to understand 30%, but you need to understand if you don't have this subject. Any other questions I can answer for you guys?
Yeah, sorry, I just have one last question. Is it possible to have more than one class a week? Because like I don't know about anyone else, but I'm kind of writing two more exams in January. So I
Mm-hmm.
didn't want to like have that overlap with the other exams, rather be done before then.
Oh, okay. Yeah, it is possible. But I don't want you guys to download with a lot of knowledge at one time so that you guys get little confused. Okay, what was that? What is it? So the topics which are really, really important, I'll take a one class at a time. The topics which are not very important and you guys can cope up with that much of knowledge, we can take two classes and quick classes on that. But basically, because as I know how NCA portray all such things, I want you guys to separate few things in your mind, that this is a contract and this is taught. Then I want you guys to uh, put that much effort and those many classes at least to understand the basic things. I know IREX are good. I have those IREX and I passed my exam at first instance by having those IREX, by answering those questions. But again, I always recommend to take a bit of time and put efforts to understand those extra things to cover the risk. You understood what I'm trying to say? I don't want you guys to enter examination hall with any kind of risk or lack of knowledge. So rather than running quickly, it's better to just absorb important topics right in a right manner. You got it?
Yep.
Perfect. Any other questions we can answer today? Hello? Okay, so I guess no questions. What I'm gonna do is I'll leave this video on introductory class group so that you guys can have a look again if you want to, or those who are not available, who are not present here, they can have a look later. And whosoever want to join classes, they can just leave the message below and I can add them in a regular group. But the people who want to join, I'll recommend them to join as soon as possible, not because I want to, just because it's important to start as soon as possible. I don't want you guys to rush.
Sorry, I just had one more question. When would the classes commence if we do decide to take it with you?
Sorry, what? I didn't get your question.
When would the classes start? Like when would we?
Next Thursday.
Okay.
Okay. So it will be starting from the next Thursday, the same time, and it will be approximately 2 hours class.
Sorry, 6 p.m. BC time?
That's it, because I'm working and I get free by 5 p.m. So it's better to take class by 6 p.m.
So is it going to be every Thursday if the classes are
Yes,
held?
every Thursday. Yeah, that's right.
Sorry, so if it's next Thursday it's starting, I'm assuming that we're going to be done by like mid-January. So if you do want to write the exam, the January sitting, it should be fine for timeline.
Yes, I think it
Okay,
because
great, thank
we
you.
start from the next Thursday. But if it will be like if I'm like I'm always if you ask my property law class students, I always cover my syllabus beforehand, and I like to do that so that you guys have enough time to revise everything. So if it will be important or necessary, I'll take 2 classes in a week to cover the syllabus. But I wanted to start with E so that you should understand the basic initial concepts. With I don't want you to download with a lot of knowledge there. So afterwards, once you will be comfortable with basic concepts and basic categories, then we can go quickly. So by the end of the December and the start of the January, there is a possibility I'll go and opt out for 2 days in a week. But right now, I want you guys to start with the basic concepts and the basic categories. So it's important. Any other questions for today?
So when will your notes be available?
Once you guys will sign in, I'll put it on group.
Okay, thank you.
Perfect. And I always recommend to have a book also, but I know students don't like book much. They always wanted to have notes because it's summarized, it's quick and easy. So it's up to you guys completely. What you guys want to go with,
How
right?
many pages are your notes?
Sorry,
How many pages are your notes?
it's approximately 80.
Okay.
80 pages. But I will change a bit now because syllabus has been changed. So I have to add on few of the things and I have to take out few of the things. So my bit may differ this time.
Okay.
Perfect. Any other questions? Any further questions I can answer for you guys today? Nothing? So we can see off now? Okay, fine. So I'll take a leave now. Have a great evening and I'll see you guys soon. Whosoever will sign it. Okay? Bye
Thank you
for
very
now.
much.
You're welcome.
Thank
Bye.
you. Bye.
Thank you, bye.